I am Dr.S. Saraswathi, Associate Professor, PG Department of Commerce. Now we shall discuss the topic about business law. Mercantile law. Mercantile law, also known as commercial law or business law, is that branch of law which governs and regulates trade and commerce. Next on scope of mercantile law. With the increasing complexities of the modern business world, the scope of mercantile law has enormously widened. It is generally understood to include the law relating to contracts, sale of goods, partnership, companies, negotiable instruments, insurance, insolvency, carriage of goods, arbitration, etc. The term mercantile law is used to denote that branch of law which deals with the rights and obligations arising out of mercantile transaction between mercantile persons. The next one, source of mercantile law. Indian mercantile law is largely based on the English mercantile law. However, necessary modifications have been made to provide for the local customs or usage of trade as necessitated by the peculiar conditions prevailing in India. It is important to note that in the absence of any specific law or customs or usage on a particular point, the rules of English commercial law are still applied by the court in India. Indian Contract Act 1872. The law relating to contracts in India is contained in Indian Contract Act 1872. The act came into force on the first day of September 1872. The act as it now stands contains the general principles of contract, contract of indemnity, surety, bailment and agency. Other branches of contract are now governed by other acts such as the Partnership Act, the Negotiable Act, the Sale of Goods Act, etc. Within the limiting principles laid down in the Indian Contract Act 1872, the parties may create rights and duties between themselves. Section 1 to 75 deals with the special type of contract. Section 124 to 238 deals with the special type of contract. The special type of contract such as contract of indemnity and guarantee, contract of bailment and pledge, contract of agency. Next one, classification of contract. Contracts may be classified into the following three main categories according to enforceability, that is legal validity, according to formation, that is mode of creation, then last one according to performance. First one, classification according to legal validity, valid contract. A contract which satisfies all legal requirements laid down in section 10 of the Act is known as a valid contract. A valid contract is an agreement which is binding and enforceable at law. Next one, void agreement. An agreement not enforceable by law is said to be void. A void agreement has no legal effect. It confers no right on any person and creates no obligation. Then third one, void contract. A void contract is that which is not enforceable by law. Of the Act lays down that a contract which ceases to be enforceable by law becomes void. When it ceases to be enforceable, a contract which is enforceable by law at the time it was made, but later on if it becomes legally unenforceable due to some reasons, it is called void contract. For example, A promised to marry B, later on B died. In this case, the contract becomes void on the death of B. Next one, voidable contract. An agreement which is enforceable by law at the option of one or more of the parties thereon, but not at the option of the other or others, is a voidable contract. Such a contract is voidable at the option of the aggrieved party, the party whose concern was so caused. In such cases where the concerned is not free, the parties whose concern is so caused become the aggrieved party, who can either affirm the contract or set aside or rescind it. For example, A agreed to sell his car to B for rupees 50,000. The concern was obtained by use of force. The contract is voidable at the option of A. A can put an end to this contract if he so decides. The next one, illegal agreement. An agreement is illegal and void if its objects or consideration is forfeited by law or is of such a nature that, if permitted, it would defeat the provisions of any law, or is fraudulent, or involves or implies injury to the person or property of another, or the court regards it as immoral or opposed to public policy. Then last one, unenforceable contract. The unenforceable contracts are those which cannot be enforced in a court of law because of some technical defects. In certain cases, there are special provisions of law which require some formalities to be fulfilled. There are special provisions which provide that a contract must be in writing, or it must be registered, or it must be properly stamped, or it must be attested, etc. Next one, classification according to formation. There are three types: express contract, implied contract, quasi contract. First one, express contract. Express contract are those contract the acceptance of any promise is made in words. The promise is said to be express. An express promise will result in an express contract. For example, A writes a letter to B that he offers to sell his car for rupees 60,000, and B in reply informs A that he accepts the offer. This is an express contract. Next one, implied contract. Implied contracts are those contracts such proposal or acceptance is made otherwise than in words. The promise is said to be implied. For example, Mr. X went into a restaurant and took a cup of coffee. Then last one, quasi contract. There are certain dealings which are not contracts strictly, though the parties act as if there is a contract. In fact, it is an obligation which the law creates in the absence of any agreement. For example, Mr. X supplied Y, a lunatic, with necessaries suitable to his conditions in life. In this case, X is entitled to be reimbursed from Y's estate. Then last one, classification according to performance. There are four types of contract: executed contract, executory contract, unilateral contract, bilateral contract. First one, executed contract. When both the parties have completely performed their respective obligation under the contract is said to be executed. For example, cash sales. The next one, executory contract. In this contract, the obligation of the parties are to be performed at a later time when both the parties have not performed their respective obligations under the contract. The contract is said to be executory. Then third one, unilateral contract. In certain contract, one party has to fulfill his obligation, whereas the other party has already performed his obligation. Such a contract is called unilateral or one-sided contract. Last one, bilateral contract. Bilateral contract is one in which the obligations on the part of both the parties to the contract are outstanding at the time of formation of the contract. For example, Mr. A promised to paint B's house for a sum of rupees 500. It is a bilateral contract as there is exchange of promises and obligations of both the parties are outstanding at the time of formation of the contract. That's all. Thank you.